in the matter of Crab Creek Conservancy, Inc. et al., 2408-2023. Good afternoon. We are in the afternoon, technically. Mr. Nelson, you've reserved 8 minutes for rebuttal. Thank you. And we have Mr. Hyatt. You're taking 15 minutes, right? And Mr. Lyles 5 minutes. Is everyone settled in? Okay. All right, you can begin when you're ready.
If it please the court, Mason Nelson on behalf of the citizen appellants. It's been a long morning, I know. So thank you for sticking with this one. This is a land use case arising out of the city of Annapolis, and it concerns the interpretation of the City of Annapolis Forest Conservation Act. I represent citizens who live around the proposed development, and the issue in this case are two variances. First, the Planning Commission approved a variance to cut 27 acres of forest and a variance to cut down 64, what the ordinance calls significant trees, which are a type of tree greater than a certain size.
In your brief, you refer to the 27 acres as priority forest. Are we talking about contiguous forest?
I think those are synonyms. The ordinance speaks about priority or contiguous.
Okay. And that would be contiguous forest as defined under the city charter, under chapter 2171.
That's right.
Okay.
And maps, when I look at it, get a new case, maps help me understand the case, and that's why in our opening brief at page 7, we included an illustration from extract 78, which we annotated. We described how we annotated, and that map came from extract pages 78 and 79, and I apologize because the page numbers in the extract are small, but those maps help me understand just the lay of the land. This is a Forest Conservation Act case. To me, as an advocate for citizens in land use arena, it's an interesting case because this is a new emerging issue in Maryland land use law. And we know about the Craig Westport case, which talked about the final appealable issue in that case. The Western Montgomery County Citizens Association case has 1 or 2 sentences on the Forest Conservation Act. And then Judge Keogh and Judge Nazarian were on a panel several weeks ago or months ago where the court addressed in an administrative mandamus case a Forest Conservation Act issue. So this is, I believe, an emerging issue. And we don't have a lot of law to point to when we analyze the issues in this case. But the remand order from the circuit court, understand that there was a planning commission approval, my client's petition for just review, vacated on the forest conservation piece, and the remand order appears at extract 437. It's just 2 or 3 or 4 sentences saying in crystal clear what the court wanted the planning commission to do on remand, and this is how I understand the issues in the case. There are 2 general categories of, there's the priority forest or the contiguous forest. There's the so-called category of 64 significant trees. And one of the first questions is, who makes the decision regarding the removal of the priority forest? Planning Commission or the Department of Planning and Zoning? We, the citizens, argue Planning Commission. My adversaries argue, no, DPZ, Department of Planning and Zoning. So that's a legal question. Next question is, well, if it is the Department of Planning and Zoning, did they make a decision in this case? We say no. And is there any articulation as to what they found? We say no. And then we say that if the Planning Commission is correct, that the Department of Planning and Zoning is the decision maker on the priority forest variance, what are the criteria that the that the DPZ must use when making that decision. So those are the general questions with respect to priority forest.
Isn't there another more fundamental issue that you flagged in your brief, and that is that regardless of whether this resource falls within a contiguous forest category or a significant tree type, that all of it has to be subject to the variance standards under subsection 170B 1 through, I forget how many there are.
Yeah, the court's precisely right. I was going to get to that, but I'll talk about that now. But the point I was going to make just very quickly was the Planning Commission said that DPZ has total discretion to grant a variance for the removal of priority forest for any reason it wanted. Discretion, that's an extract 444, I think it is. But let me address Your Honor's question. And the parties wrestled over this issue. And this speaks to the priority forest piece, where my clients argued that yes, the Planning Commission had to evaluate that case in accordance with the criteria set forth in 21.71.170 B1 through 6. And my adversaries say, not so fast, Nelson. We disagree, because the way, this is my adversary speaking now, the way we read the ordinance, the priority forests have a different, less rigorous mechanism for review. And I think that's...
Doesn't it say under section 80B, and then it separates out 1 and 2? The contiguous forest that we're talking about, the 27 acres that the applicants seek to clear, wouldn't that fall under B1, 2?
I have to pull out that precise ordinance, but and I want to think about what Your Honor just said, but the way I analyzed it, it was a little bit different. We know that if we look at 21.71.070, the little 3 little I's, it says you need to qualify for a variance to remove a priority forest.
Well, but this is where I was asking you earlier about what you mean by priority forest versus contiguous forest. So this under triple I says how the disturbance to the priority forest and priority areas specified under natural resources 5-1607C2. So is a contiguous forest fall under natural resources C2?
Yes.
It does?
Yes. You say it does.
Let me just check here. I don't see it listed under C2 of the natural resources. It lists wildlife, endangered species. It lists trees having a diameter of 30 inches or more. But contiguous forests is listed under C1 of natural resources.
The language of the ordinance says priority forests specified in Natural Resources Article 5, 1607, et cetera.
C2.
C2.
So contiguous forests, and we've established that when you're referencing the 27 acres, you're talking about contiguous forests as defined under the city code, doesn't fall under C2.
We assert it does.
Okay, where in the language of natural resources C2 does it say contiguous forest is listed?
We can look at the words together. I don't have that in my extract. But then, if we look at...
Well, would you agree at least that if it's not listed under C2, that there would be no need for the applicant to show to the satisfaction of the department that that qualifies for a variance?
No, I don't concede that.
Well, C2 is attached to it's attached to the back of your brief. I'll read it. It's on, well, these pages aren't numbered. But this is, it's 5-1607 C2 says, following trees, shrubs, plants, and specific areas shall be considered priority for retention and protection. This page has a 3 at the bottom of it, but that's just the 3rd page of this particular statute. And they shall be left in an undisturbed condition unless the applicant has demonstrated to the satisfaction of the state or local authority that the applicant qualifies for a variance under section 5:1611 of this subtitle. And then it says, Romanet I, trees, shrubs, or plants identified on the list of rare, threatened, and endangered species of the U.S. Fish and Wildlife Service or the Department, so we don't have that, right? Romanet 2, trees that are part of a historic site or associated with a historic structure or designated by the department or local authority as national, state, or local champion tree. I don't think we have that, right? Okay. And then Romanet 3, trees having a diameter measured at 4.5 feet above the ground of 30 inches or 75% of the diameter measured at 4.5 feet above the ground of the current state champion tree of that species as designated by the department.
That speaks to the significant tree piece.
Okay.
I'm,
There isn't anything about the contiguousness.
yeah, I
or
don't mean
priority of the
to
forest.
speak over the court, but I'm focusing. Variance must be submitted to the planning commission or the zoning board. And then it says if the case goes to the planning commission decides, I'm paraphrasing, decides the variance. So I'm trying to make and one of the problems.
Yeah, but the second half of the first sentence in F says, any variance must be submitted to the planning commission or the zoning board of appeals, whichever the case may be, with the project or development plan application for final determination. So it's part of the whole package, right? And isn't that sort of the ultimate decisional question here? If the ultimate package gets decided by the planning commission, then even if the department decides in the first instance what the tree components ought to be, isn't the planning commission ultimately deciding the whole package one way or the other?
And I just need a few seconds to answer that question because yes, yes, yes. And the whole package, one of the reasons this case is so complicated is a very complex, large development went to the planning commission, the whole package, and one piece of it concerned the Forest Conservation Act.
Right.
So our thesis, if it pleased the court, is that because the whole package, to use the court's phrase, was going to the planning commission, and that included the variance applications, 2 of them, the planning commission needed to do it. Here, the planning commission said, no, DPZ is going to decide the priority forest or contiguous forest variance. And number 2, there was no decision in the record by DPZ, only a recommendation. And number 3, they didn't articulate any rationale in support of it. And number 4, the planning commission said the DPZ can use whatever discretion it wanted to make that decision. So I have 7.5 minutes and a lot to cover. So thank you for bearing with us on this one.
Thank you very much. Mr. Hyatt, 15 minutes. And as you, maybe before you, when you start, you can explain to us and walk us through kind of the procedural steps of how a planned development application works under Chapter 2124 and how the forest conservation piece fits into that procedural scheme.
Thank you, Alan Hyatt, for the appellees. Other than the city of Annapolis, Mr. Lyles is handling that. May it please the court, let me talk about the statutory scheme. This is an application for a planned development under 21.24. Among other things, the city of Annapolis requires that an applicant satisfy the forest conservation law in the city of Annapolis under Chapter 21.71. Now, 21.71 is the City of Annapolis's adopted Forest Conservation Act as directed by the state law under the Department, or under Natural Resources article. So what is before the Planning Commission is one variance request, and that variance request is to disturb what they call significant trees in the city code. The state law talks about 30-inch trees. The city is more restrictive and discusses significant trees as being 24 inches. So what you have is several of these statutes that are in the appellant's brief, but they interact with the Natural Resources Article 5-1607, which you referred to. And there's a hierarchy of treatment of natural resources and forest.
Before you get into the hierarchy, this plan development application, was this in a preliminary, or are we at the final?
Oh, this is a final
Okay.
plan development
This is
application.
the final conservation plan, and we're
Well,
at the final stage.
No, the variance is final. The variance that was approved and the plan development was approved, but the forest conservation stage is preliminary
Okay.
forest conservation plan, which is not an appealable item under the city code. But, you know, that's when all the matters pertaining to forest are submitted to the Department of Planning and Zoning. But what you have here is clearly this hierarchy of treatment of natural resources. You have something designated as contiguous forest, and then you have the significant trees. Matters pertaining to the significant trees require a 21.70.170 variance. That you have to satisfy. When it comes to contiguous forest, you do not need a 21.71.170 variance. That is within the discretion of the department, and it's spelled out very clearly in 5-1607C1 and C2. It is spelled out very clearly in 21.71.080 B1 and B2, and that is where there's this distinguishing factor between contiguous forest and trees that are either specimen trees or significant trees, as the city calls them. And so there's no requirement for a variance for contiguous forest.
A question about the department's discretion. Under 2170-80 B1 and 2.
Yes.
Under both circumstances, whether this resource falls under the category of a contiguous forest or a significant tree that qualifies for a variance under 170, the applicant has to demonstrate to the satisfaction of the department in both cases, right?
Well, when there's an application before the Planning Commission, it stands in the shoes of the department for a variance determination. That is in 2171-170F. So the department is substituted by the Planning Commission when it comes to that variance. When it comes to a contiguous forest, the department makes the decision, and that's the distinction between, under 2171-080 B1 and 2.
But doesn't the department have to engage in some sort of review process of the forest conservation law under B1I and
Yes.
B1 and 2? Right, so then how does the department express or memorialize its satisfaction with the applicant showing? Is it in a memo? Is it in the staff report? Does it have to be in something else?
I don't think there's a requirement in the code for a writing for this. There is a requirement in the code under 2171-170 for a variance that there has to be written findings under C, subsection C. But when it comes to this stage of the proceedings, the department has to make a determination to its satisfaction that these reasonable efforts have been made and to protect the contiguous forest and they cannot be reasonably altered. So there's nothing that the department issues that is a consideration for an appeal, for example, because we're at the preliminary forest conservation plan stage, and the recommendation from the department in favor of the application, I guess it's the inference that they've found satisfaction.
Well, I thought you were going to say that something to the effect of the ultimate decision to approve the planned development encompasses this, right? That maybe there's not a specific writing that comes out of the department, maybe separate from the staff recommendations, but that ultimately there's a decision to approve this development with all of its different components, and that what I thought you were going to say is the commission's ultimate decision to approve all of that encompasses those decisions and conditions.
That's accurate. I was responding to the question of whether there was a writing. There was no writing.
I know you were, but I thought you were going to get to that.
But one of the standards to satisfy in a plan development is that the Planning Commission has to determine that the plan development application satisfies 21.71, and that was their conclusion. So yes, it's all rolled into it, but there's still another step. Just, there's a final forest conservation plan that has to ultimately be approved.
Well, does the department, I'm just trying to think in terms of how it works practically.
Yes.
This is all done in the context of 2124. The forest conservation piece is one piece. One piece of the forest conservation is that the department has to be satisfied of certain showings. And does the department express its well, I don't know if approval is the right word, but that it's satisfied with these various showings in a staff report? I mean, the staff report is part of 2124.
Correct.
Right?
Yes.
So is that, I remember the term baked in somewhere
Yes.
in the circuit court proceedings. Is that
Yes.
baked in to the staff report?
It is. The staff report, and there's several iterations of the staff report, makes the recommendation in favor. It says that the applicant satisfies 21.71, and then it articulates specifically the standards of the variance.
So then where does, going to section 170C, it says that the department shall make written findings that the applicant has met the requirements of subsection A, B, before the department may grant the variance. So where does that subsection have any application in this context?
That subsection only pertains to the significant tree variance.
So what, did the department grant a variance of the removal of significant trees?
The Planning Commission granted the variance, and I, again, refer you to F.
Right.
2171,
Right.
170F,
But then it
because
says the department needs to make written findings of it.
it did. Not the
department.
department, no, the Planning Commission. And then this is where,
This is,
I
then
know.
that interpretation is a bit inconsistent between C and F.
well, but F says a variance must be submitted to the Planning Commission. So the Planning Commission effectively stands in the shoes of the department. The department does not weigh in on variances. It's the Planning Commission.
Okay.
So that the Planning Commission did, in fact, issue written findings in support of the variance application. They spelled that out in their opinion. And that's the only entity that had to do that. Even though it says department, just remember that the department is substituted,
Where does it say that in the statute?
well, in F.
Is there a situation where the planning commission or the zoning board are not part of the decision-making process of a variance? Would that fall under the last sentence of F?
Yes, if a matter does not come before either the Planning Commission or the Zoning Board of Appeals, and it's strictly an administrative matter, then it's all the department at that point in time.
Okay, thank you.
Okay, so that's, and it's a little confusing, I'll acknowledge, but if you go through it step by step, I think it becomes clear that contiguous forest does not require a 2171, 170 variance, despite the appellant's position, but any impact on significant trees does, and that's handled by the Planning Commission, and the Planning Commission, I think, handled it appropriately, as did the circuit court judge.
With respect to 70A5,
Yes.
double I, triple I,
Yep.
versus 80 B1 and B2. There seems to be some overlap, a little bit of overlap. Do you know why there are such provisions there and why it couldn't have been consolidated into one? I mean, there has to be some reason. It seems like 70 talks about the forest conservation plan, and it seems to suggest these are certain things that the environmental consultant needs to address under II, III. But then the 80 piece talks about the retention piece.
Right.
So can you help us understand why these are in two different sections and what this all means?
I think 70 is the more general. It's like a, it covers the broad concepts of the forest conservation plan, but then it's amplified in 80 very specifically about when a contiguous forest is, or how a contiguous forest is handled and how specimen trees or significant trees are handled. And it's slightly redundant because both say some of the same things, and 70 refers to 5607C2, as you mentioned. 1607C2 of the Natural Resources article is significant trees. It is not contiguous forest.
Well, C2 doesn't necessarily include significant trees. There's some overlap in the definition of significant trees, and they include champion trees.
I know.
But it's stricter, at least in the city code, that it includes 24 inches in diameter, which is
right.
not covered under C2.
Well, C2 talks about 30 inches.
It talks about 30 inches. So in theory, a consultant may not have to address under 5 III why a significant tree of 24 inches in diameter has to qualify for a variance.
But under the law, the municipality is allowed to have a more strict ordinance than what's called for under the state's Forest Conservation Act. And the city of Annapolis is more strict than the state law, and it mimics generally the model ordinance which is contained in the in COMAR.
So to address the other side's point about qualifies for a variance, or maybe it was a point that was made below, qualifies for a variance without the following phrase in accordance with 170 is missing, right?
It is.
Okay. So what would be the practical purpose for excluding that clause?
I don't have an answer for you specifically. I think that it refers to 51607C2, which is when I refer to the hierarchy, that's the more significant, or that's significant trees, but that is that's the higher standard that's considered.
From a practical standpoint, if you're the environmental consultant who's supposed to prepare a forest conservation plan, how is that person supposed to satisfy the department if there are no standards here? Well,
but there are in the city. I mean, the city has its own definition, and so I think you look at 51607C2, but then you have to look at the more narrow standard that has been adopted by the city, so it's 24 inches and not 30 inches. I think.
But in terms of qualifies for a variance, that piece.
Well, the only variance would be under 2171-170. That's how C2 would have to be handled. You have to meet those standards.
Okay.
My few seconds left, I would like to point out to the court that we believe there was a failure to preserve before the Planning Commission. Many of these arguments, all of these arguments, came later. The appellants had ample opportunity to raise them before the Planning Commission and didn't do that, and that deprives the Planning Commission of an evaluation of these issues. And it's fundamental that failure to preserve takes the appellants out of this case.
Well, there may be some argument that the appellants didn't preserve certain arguments, but in terms of the issues raised in your motion to dismiss, it's either raised or decided by the lower tribunal. In this case, the commission decided the issues that are being raised, maybe certain arguments were not preserved, and we can ask the other side about that. But in terms of the issues raised, so that's the interpretation of the code with respect to variances, and then the unwarranted hardship piece, that the commission decided.
But they weren't raised. They were not raised by the appellants, and you know, it was not in front of the Planning Commission. That's my point.
Okay.
All right, thank you.
Thank you. All right, Mr. Lyles, you have 5 minutes. And maybe you can shed some light into some of my earlier questions.
We'll do our best, Your Honor. May it please the court, my name is Mike Lyles. I'm the city attorney representing the city of Annapolis, and we adopt the arguments and are in total concurrence with the appellee represented by Mr. Hyatt. But we're here to make sure that this court sees the forest for the trees. There is confusion in the code. However, there is no confusion in what the Planning Commission ultimately decided. And that is why we're here, because that is what's being appealed. This court has spoken eloquently over the years, and we want to highlight that in order for this court to delve into what the Planning Commission did in its decision, there's a pretty high bar, and the appellant hasn't met it. One, he has to walk through the door of whether or not the Planning Commission had substantial evidence before it to make the decision it did. We are confident that it had substantial evidence, with over 500 pages of a record evidencing multiple hearings over more than a year. There are numerous witnesses, advocates for the project, advocates against the project who are now for the project, and uncontrovertedly, experts who opined on all of the issues that you're now raising. Mr. Klobasco, wetlands expert, testified about whether or not wetlands would be affected by the development. Mr. Arison, a land planner expert, testified about whether or not the variance was appropriate and whether or not there was uniqueness to the property that makes the variance application appropriate. Also, Mr. O'Leary, who testified about stormwater, afforestation, forest conservation. Taken together, what all of this means and what the commission heard was that the project moved to one section of the property, reforesting the property, planting more trees than are required, actually improves the natural area more so than leaving it the way it is. Why? Because the planting of additional trees, more than 125% more than is required, planting those trees in sensitive areas, replanting trees, significant trees, making sure that the project, the development, the buildings were in a certain area would improve water quality.
I understand that piece of it, but can you talk a little bit about the department's role in the review and assessment process of these aspects under 70 and 80?
Sure. What happens often in these cases where under 2171, the department is the first to see the application, especially in this case for a variance. The staff report is reviewed by the Planning Commission, and the staff actually testified in front of the Planning Commission. In fact, in record page 128, the staff report commented that the variance, which is what was before them, is not the result of actions by the applicant, which was one of the contended issues below. Additionally, the Planning Commission staff report, the DPZ staff, said the request to remove 64 significant trees do not arise from any condition on the neighboring property. The variance request pertains to environmental conditions. The particular trees proposed for removal, which require a variance, are located generally in the northern section of the property. So all of those things were in front of the commission, which had to actually approve the interpretation of the code section about whether or not it was proper for Planning Commission to grant the variance.
Are you saying then that the staff report is the department's expression and communication that the applicant has satisfied all these things under 70 and 80?
It is. And what happens, and I think was well articulated by the court, it's the planning commission that has to ultimately decide the whole application,
Right.
which includes
the
the variance request, which was granted in this case, which was recommended approval by the planning commission staff.
When does 170C ever play a role in this process, if at all?
Well,
This is the part about the department shall make written findings that the applicant has met the requirements of A and B before the department grants a variance.
yes, if I might, it describes it too, and if you look at F, any variance must be submitted to the planning commission or the zoning board of appeals with the project or development plan application for final determination, and that's where we are. If the variance is sought with a site design plan application not requiring planning commission approval, the department shall issue the final determination. Here, the department didn't issue a final determination.
Okay, so you're saying C applies to the last sentence of F?
Correct. Well, I guess I'm making the point, just make sure that we're making the correct point. That what we're talking about is the variance was asked with relationship to the project or development plan application for final determination.
Okay.
So the DPZ staff didn't approve the final application, the application for a variance, because we weren't in a site design plan application process.
Okay.
Okay, and so we would, and so before the planning commission was substantive evidence. Additionally, to the confusion of what the court might see as some of the contradictions in the code, the opinion of the planning commission laid out and interpreted what we're now going through and found that the variance was appropriate. They were going to grant the variance, and that there is no, and that this court should view their interpretation within the context of the vast weight of case law, which gives the planning commission discretion to interpret its own code sections for which it has authority. In this case, it found, and this can't be taken out of context, that we're talking about a development that actually improves the property, improves the land, provides more than what is required with respect to forest conservation, water quality, tributaries and streams are improved. The Planning Commission has to look at all of that because that's the point at which they're making a decision on this entire application. And we think that the appellant has failed to provide a rational reason, a rational basis or logic, factually or legally, to divert from what this court has always decided, that the agency decisions, administrative decisions, are somewhat sacrosanct and should be given great deference. And with that, we would ask that this court uphold the Planning Commission's decision.
Thank you.
Thank you, Your Honor.
All right, Mr. Nelson, you have 8 minutes.
I agree that the ordinance is confusing. Mr. Lyles agrees, and I would urge the court to consider the opinion in Craig Westport where the court talks about the purpose of the Forest Conservation Act, because that opinion informed the way we try to reconcile all these inconsistencies in this ordinance. That's one of the reasons I made the point that I think this is the first case interpreting this ordinance.
So are you saying that we can look to the natural resources article for sort of, it can be informative in terms of what the city code embodies under 2171?
I think so. Yeah, I think so. So I'm going to try to just crystallize our argument. We assert that the Planning Commission, I'm speaking now about the priority forest, the Planning Commission was obligated to make a determination on the variance for the priority forest. We've briefed that, we've argued it. My adversaries say no, the Department of Planning and Zoning had the obligation. And let's just assume that the court concludes that DPZ had that authority, which we don't agree to. But if they did, I'd ask the court to ask yourselves, where is the decision by DPZ?
All we said was that the DPZ decides what package of tree conditions to recommend, and that's the department's role. It goes into the staff report, and that the ultimate decision to approve the development plan with whatever variances are required in connection with the Forest Conservation Act or the city Forest Conservation Ordinance are encompassed by that ultimate approval. I thought that's what Mr. Hyatt said. maybe I misheard, but in
Maybe.
other words, so the answer to the question you asked us, I think from them would be the ultimate decision to approve the development plan with its forest conservation elements in it is that decision. Is that wrong, or would it, if it's correct functionally, does that somehow not satisfy
It's not
the
what,
law?
Judge, I could be mistaken, but that's not what I understood my adversaries to be arguing. I understood them to argue the following. Let's talk about the priority forest. That has a less rigorous review mechanism, and this is them speaking, in the ordinance. And under the ordinance, my adversaries argue, the Department of Planning and Zoning makes that determination. Therefore, you ought to reject Nelson's argument that the case should be vacated because the Planning Commission didn't do it. So all I'm saying, I've argued that point in their papers. But I want to say, let's assume for the moment that the department was the body that made the decision on the priority forest variance. They didn't make a decision. They made a recommendation at E129. They made no discussion of the priority forest piece. I direct the court to extract 125, where they discuss the significant tree piece, but not the priority forest piece. I direct the court to E111, where there's a superficial discussion of the priority forest in a sentence or two, but there's no analysis of why the Department of Planning and Zoning determined that a variance for the priority forest variance should be approved. Then, I've been raised to think that when an administrative tribunal makes a decision, it does so in accordance with certain prescribed criteria established by the legislative body. That's the way this administrative law works. So I'm going to extract 440. Now the Planning Commission is saying, look, DPZ is the decision maker on the priority forest. This is the middle of page 440. It is the Commission's opinion, I'm reading the decision, it is the Commission's opinion that the method of review for determining whether the proposed disturbance to priority forests and priority areas qualifies for a variance is left to the discretion of the department. Left to the discretion of the department. We say that's legal error.
Is your position, once the Planning Commission has jurisdiction over an application, then everything comes before the Planning Commission de novo? In other words, the priority forest would come before the Planning Commission de novo?
Yes. And here the Planning Commission made no finding of fact, no determination about the priority forest in its decision. And my adversaries concede that. They don't view it as a concession, but they state that. Yes, I agree with that statement. I have 2 minutes, 50 seconds left.
The Commission says that the material submitted substantiate qualification for a variance to disturb contiguous forest and priority forest. Now, they used contiguous forest and priority forest. I don't know if it's interchangeably or if they're making a distinction, but they include contiguous forest. So the Commission did address that piece, didn't it?
What extract page were you, Your Honor?
I think it's E439, or it may have been 440. It's towards the end of its.
I see that sentence. Maybe I have a worldview that's different than Your Honor's worldview. But in administrative law, you need to articulate what you did and why. You need to articulate the law. You need to articulate your findings of fact. And that superficial statement is a conclusory statement that doesn't satisfy any requirement in our jurisprudence about what an agency, I respectfully suggest, must articulate. May I turn very briefly to the significant tree piece? We all agree that the criteria set forth in 21.71.170, B1 through 5, applied to the significant tree piece. And this is a classical, in my view, variance analysis, which requires, among other things, a finding of, they use the phrase special condition, which is a synonym for uniqueness of the property.
Well, uniqueness is used in the zoning ordinance, but it's not used in the tree there, or the ordinance under the forest conservation ordinance, and
That's correct. I've been informed by this court's opinions in Dan's Mountain particularly.
but
where-
Dan's Mountain's a zoning case, and this, the ordinance, the variance for forest conservation does not use the term uniqueness, and Comar section 08190302 specifically states that a variance under Natural Resources Article sections 5160, 601 to 5612, variance does not mean zoning variance. And so does the zone, is the zoning, our question is the zoning analysis where you talk about uniqueness an apposite, because that term is not used in the forest conservation variance, but it is used in the zoning variance.
May I have 45 seconds?
Yeah, take your time to
Our
answer. I
time
mean, this
on
is a
us,
big
so go
question.
ahead.
That's an issue that we've thought about a lot in our practice. You're not the first person to make it to me. And we look across the spectrum of the critical areas law, all the various laws, we briefed this, and the ordinances use language that's similar to the language that we see in 2171.170. The language is the same. I'm not saying to the letter the same, but is essentially the same. But the point,
But essentially, this gets into essentially much of the language parrots on these two ordinances. But the specific word unique is in the zoning ordinance, but not in the tree conservation ordinance.
correct, and I just look at this court's jurisprudence where it talks about, Judge Friedman especially, and I know that's a zoning case, but, and I read those cases to say that these are synonyms. But I don't think we need to get hung up. I think the court is saying to me, Nelson, this ordinance uses the phrase special conditions peculiar to the property, which would cause the unwarranted hardship. So I'll use that. To me, it's the same thing, special conditions. So in this case, the Planning Commission is saying that the density of the significant trees is the special condition peculiar to the property,
Right.
right? So I'll use that. And this is the theme we're trying to make.
But there's a line that Dan's Mountain talks about, and that is under the zoning analysis, and it's in the zoning ordinance, that the property itself is unique versus the tree conservation ordinance talking about special conditions.
All right. I think they're synonyms, but I want to address the argument the way the court is framing it, which is, Nelson, this ordinance speaks to special conditions peculiar to the property. It doesn't speak to uniqueness. I think that's what the court's saying to me. And you're saying, what's your response to that? Here is my response.
I'm not saying it, I'm asking.
Okay, okay, all right. I'm sorry, I'm sensitive. The special conditions that the commission points to in this case is the density of the number of significant trees where they want to build this project. Our theme is this. You can't cite as a special condition a characteristic that the ordinance is designed to protect. Because if this property satisfies the special conditions peculiar test or the uniqueness test, whatever word you want to use, because of the density of the number of, I'm hesitant because some ordinances say specimen trees, this says significant trees, that you can't use what the statute is designed to protect to justify the grant of a variance.
But the plain language under 170B1 doesn't preclude consideration of those environmental features. I mean, to some extent, we've got to look at the plain language. All it says is special conditions peculiar to the property. It doesn't say, you know, those types of resources can't be considered and factored in. Versus, if you look at the zoning law under 2128, then you're talking about something more specific, because the language says you consider shape, topography, and all these other things.
I never said this was going to be easy. I'm an advocate for a certain group of people. We do a number of these cases. I think these cases are going to be coming down the pike, like a lot of them. And our thesis, not yet found by any court, not yet rejected by any court, but it's a thesis we're making in this case, is you can't look to a condition and have that be the basis for a finding of a special condition or uniqueness if that's what the ordinance is designed to protect. And that's why I open my remarks to saying these are new issues. That's why I urge the court to read Craig Westport, because it informed my view on these issues. And I look at that case and I read what Justice Bruce wrote. And the point is, we want to protect, for a myriad of reasons, we want to protect our forest canopy. And it ought to be interpreted in a way that achieves that goal. And that if this applicant is entitled to a variance for the removal of these significant trees because he's got them, makes the whole ordinance, the whole statute meaningless. In our papers, we talked about standard review. I didn't brief it here earlier, but these are legal questions. They're new issues. They haven't been tested. There's not a long history of conclusions by the commission. So for all those reasons, we would ask the court to accept our arguments. And we, on behalf of my clients, we appreciate deeply the court's close review of the case. I know it's a lot.
Thank you very much. And thank you for your presentations.